Yes, so I was thinking that we should cover the proposed H-1B regulation today, simply because there's so much in that proposed regulation, and even though it's not yet law, it is expected to become law pretty soon. We don't know which elements of it will be retained and which will be taken out, but I think most of it, we can expect that most of it will become law, and it's important to look
It's
at it at
important to
this
look at
time simply because everyone is going to be filing their new H1 starting April 1st. And if the H1 gets approved, of course, then you're not affected by the regulation. So it's important that you file as soon as possible. But if it doesn't and it's pending, then and if the regulation is then published, then your H1 might get affected by it.
by.
So I think it's
So I
important
think it's
to
important.
see what is needed, meaning how to file the H1 to avoid getting into any issues with reference to the new regulations, and what steps to take to ensure that your H1 is approved in light of the new regs, new proposed regs, I must say. Also, it makes sense then, if you're a company or even if you're an individual, to maybe file your H1 this year instead of waiting for next year. Or if you're a company and you're looking to, increase your number count, I think it'll be easier to file this year, because for next year, for sure, that new regulation will be in place, and it will be more difficult to file, and I'll tell you why shortly. Moving on to the meat and potatoes of what I wanted to present today. I
Today,
wanted to look at a
I wanted
summary of the proposed regulations. There's some echo. I don't know if you guys are hearing it, but I'm hearing an echo. So anyway, I wanted to look at the summary of proposed regulations for the H-1B program, and that's what we were talking about just now. And I told you I am going to tell you now why it's so important to look at it at this point. So some of these regulations are things that USCIS has already been following as a matter of practice, but now they are being codified and made into a regulation so that no litigation can be filed against it, or even if it can be filed, they won't be as successful as they otherwise could be if it was not codified into a regulation. Okay, so the first point that they're wanting to codify is that any job that requires a general degree, for example, if you have a job that requires a bachelor's degree in, just say, MBA, a regular MBA, and not specializing in, like an MBA in finance, MBA in marketing, etc., or if it requires just a Bachelor of Arts degree, for example, then such a job would not be a specialty occupation. Another example is if your job requires just any engineering degree and not a specific engineering, computer science or chemical engineering, mechanical, etc., then it would not be a specialty occupation. So they are seeking to codify that. That has always been, as a matter of practice, what USCIS has been following. But now they're, as I said, codifying it. The second point is generally USCIS will say that it has to be a bachelor's degree. Your job has to require a bachelor's degree in a specific field. And when it's not a specific field, if it's more than one field, they send out an RFE saying it's not a specialty occupation. But now, this is good news. They're saying that it could be, your job could require a bachelor's in multiple fields of study, as long as you show that they are related. They may be different, but they have to show that they're related to each other and to the job as well. This opens up the possibility of filing a H1 for many more job titles than we previously had. The reason I'm saying this is because when they look at whether a H-1B qualifies for a specialty occupation or not, they look at a publication called the Occupational Outlook Handbook, which is available online. It's a publication published by the Department of Labor. So whenever the Department of Labor now in this publication has various job titles, so they look at that to see whether that job title is there in that publication or not. And if it's there, and if the job title, if that job says that industry standards is that the employers in this particular position generally require a bachelor's in more than one major, say physics, computer science, math, then USCIS will turn around and say that it's not a bachelor, it's not a specialty occupation. So now all those jobs which have more than one major, they'll still continue to be specialty occupation. They will now be specialty occupation, so that's good news. Opens up the H1 to many more occupations. Another point 3 is another good news, because now they're saying, previously USCIS would say that all employers always need to require a bachelor's degree for this particular position. And again, they go back to the OH, and if the OH says that most employers need it, but not all employers don't, they will send us again an RFE, and then they'll say that it's not a specialty occupation. So now they're codifying it, they're clarifying it. They're saying that it's only required that industry standard be normally, meaning normally employers should require it, doesn't mean that always employers should require it. So this is good, because again opens up many more job titles even within the IT field to be H-1B approvable. And this is important because the job titles that we usually use, software engineer is software developer, is one of the most popular job titles, and the prevailing wage is high on this job title. And they've kind of shut down the other job titles that we use, like program analyst, systems analyst. The prevailing wage is much lower, but they've shut it down by saying it's not a specialty occupation, and mainly because of these reasons. So now it'll be more easy to use these other job titles as well, a computer programmer included, and prove that it's a specialty occupation, be able to prove that. Point number 4, we know that H-1B amendments are required whenever there's a change in work location or job location. They're codifying it. They've been enforcing it as case law, based on case law, but now they're codifying the same thing. Point number 5, USCIS has always sought to give deference to existing policy, meaning if previously you had a H1 and if it's the same employer, same job, they should approve it without sending an RFE if you're filing an extension. But they don't do that. They don't follow their own policies often, and they send out RFEs even for extensions. So they're now codifying it and giving that deference policy to cover all non-immigrant petitions where the petition involves the same party and the same material facts. So even if you're filing an amendment, they should not be sending out an RFE for amendments as well. Number 6, USCIS is saying that they are going to be asking for evidence of maintenance of status. This comes into play when you're filing an extension or you're filing a change of status. They want to make sure that you are in status presently before they approve the H1. And though they have done this previously as well, looks like they want to do this on every petition going forward. This is not necessarily good news, but it is what it is. So I suggest that, we, even in the present filings, we provide evidence of status when we're filing the petition in the preliminary stage itself. Next point, the USCIS has said and continues to say that itinerary is not required. They're codifying it. They're eliminating the itinerary requirement. Previously, they would ask for a list of companies, especially if you're a consulting company, list of where you're going to be working for the next 3 years. And that was very onerous to be able to provide that list, because sometimes employers don't know where they're going to be working after the next project is over. And that would really prove to be difficult to get the H1 approved. Now because of ITSER versus Cessna, which is a court case which ITSER won against USCIS, they're not asking for itinerary requirements. Now they're actually codifying that and saying they won't ask. The next point is about validity period extension. So USCIS is going to automatically extend the validity period of the H1 beyond the period that you've asked for, especially if that period is already passed or very little a time of that period is remaining. This can happen when USCIS takes a long time to adjudicate a case, and especially if your time period that you've asked for is only a year. Also, it can happen if USCIS denies the case and then approves it upon appeal. At that point, at the time that it is approved, from that day onwards, they'll give you a year. Previously, they wouldn't do that, and even if you went through all the loops and got an approval, it was of no use, because that, in some cases, that time period would already be over. Another important remedy that USCIS is seeking to do is for the F1s. We all know what F1 cap gap extension is. The cap gap extension is where you artificially extend your extension on an F1 until October 1st. So if you're on an OPT at the time of filing, even if your OPT is no longer valid while the H-1B is pending, it will continue to be valid as per this cap gap rule until October 1st. Now they want to make that into April 1st of the next year, because this year, and the past years, when the H1 was never, sometimes the H1 is not approved until October 1st. It's approved after October 1st, in which case then, and they didn't have premium processing for cap cases in the previous years. What happens in that situation is F1 students will fall out of status come October 1st. They will no longer have the cap gap benefit. So they'll have to then either change status or extend their status on an F1 by taking additional courses. That's not required anymore because they've removed that October 1 deadline. Now you have until April of the next year to remain in cap gap status and to wait until your H1 gets approved. So that's great news for students. This number 10 is very interesting because this is for all those entrepreneurs out there who want to start their own business but who are on an F1 or and want to move to a H1 through their own company, or are presently on a H1 and want to transfer H1 to their own company. Previously, USCIS would not approve these cases because they would say that there was no employer-employee relationship. It was difficult to show that because the employer and the employee is the same person. And also because if you are an employer, then you will do administrative tasks. And if you're doing administrative tasks, those are not specialty occupation. Those are not specialty occupation duties. So they said that you didn't qualify. Now they're saying even if you own more than 50% of your company and you're doing administrative tasks, as long as the specialty occupation tasks are more than 50%, you can still do administrative tasks and you can still get a H-1B approval. The approval will be for 18 months to start off with, and you'll get subsequent extensions in 3-year increments. So that's good news, and it's important. It's an important change in the H-1B rule. Moving on to number 11, FDNS site visits. Previously, you had the discretion to allow the FDNS officer into your premises or give them information or not give them information. Now you don't have that discretion. They want to make that compulsory so that you have to provide information to FDNS officers. You have to allow them into your workplace. So this is no longer discretionary. If you don't do that, they will simply revoke the H1. Even now, they could do the same thing, practically speaking. But now, again, they've codified this. They're saying you have to allow them in. If you don't allow them in, then they will revoke your H-1B for not cooperating with the FDNS site visits. Another important change is the rule that would codify the agency's long-standing practice of asking contracts at POs, especially, again, for consulting companies. They want to make sure that the job offered is a bona fide, non-speculative specialty occupation job, which means that in the last few years since um, the IT Serve case came out and got approved in IT Serve's favor, they have not been asking for POs and work orders and contracts. We filed many H-1Bs last cap without that, and they've approved all of them. Now they're saying again, if this rule comes out, then those POs and work orders, they can ask for that again. We don't know to what extent they'll ask for them, whether they'll ask in every case, whether they will expect that you have a PO for the entire period of the H1, or they're just happy with a PO for 3 months or 6 months. So we have to wait and see to what extent they implement it, if they make it into a rule. Also, importantly enough, for those companies who are not physically present in the US, they have incorporated, they're doing their H1s, they're managing their business from India or some other country. They expect your physical presence now in the US, and they're trying to make that into a law. This is so that you can accept service, so that there is an actual person to accept service if there is a lawsuit filed against you, or if there is something that the USCIS files against you. They want to make sure that there is a person that is answerable here in the US.